Hi there, I'm Savannah Mexto with Manor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney, Bob Mannor. Today's webinar topic could be life-changing. All parents worry about providing for their kids, and we all hate to think about what would happen to those kids in the worst case scenario. Single parents, they have even more to consider, especially when it comes to their legal planning. And in this webinar, Bob will discuss these special considerations and more. Now, before I pass the torch to Bob, I'd like to cover a few housekeeping details. First, a disclaimer. Today's webinar will be educational, informative. You are definitely going to learn something new, but you're not going to get specific legal advice. If you are looking for advice that is unique to your situation, I encourage you to contact us after the webinar, and we will give you an easy way to do that. Also, if you have questions during today's webinar, please put them in the chat box. Use the chat box. That's what we're here for. We will save time at the end of the webinar to go over those questions. Also note that today's webinar is recorded. If for some reason you get pulled away, a phone call comes through, or if you just think in the middle of the webinar, man, I really wish that my neighbor could see this. Well, guess what? Tomorrow I'm going to send you a replay. You can send that to family, friends, rewatch it, share it with whomever you'd like. Now, why should you listen to what the folks at Manor Law Group have to say? First, note that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. He's currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, one of my personal favorite reasons, Manor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd love to welcome attorney Bob Mannor.
Hi folks, we're going to get right into it here and just kind of dive into some of the biggest concerns, and something that a lot of folks don't always think about, but this is particularly a difficult conversation sometimes when it's a single parent, and that's going to be who's going to be in charge of the money. So we think about it and we say, okay, well, you know, we've got some life insurance, maybe we got some life insurance through work. Maybe we get some equity in our house. Maybe we've got our 401k or IRA, and we say, well, of course, if I'm gone, I'm going to have this life insurance. I'm going to have this money. At least my child will be financially taken care of, and that's important. And most of us will think about that. But the question that I have for you is, you've thought about who would be in charge of it. So if you don't have any planning in place, if you don't have legal documents in place that are going to set that out for you, then you may have a problem. Because if you have life insurance, you're not going to want to list your 3-year-old or your 16-year-old as the beneficiary on the life insurance. That's not going to be a possibility. We also don't want to list your sister as the beneficiary on the life insurance. So a lot of people, they do that. They figure, okay, well, I want my sister to be able to take care of my child, and so I'm going to list my sister as the beneficiary. Well, what that does is it makes it so that your sister owns the money, and that there's no provision in there in case something happened to your sister, in case your sister got divorced, your sister had creditors, your sister had got in a car accident, got sick, died, anything happens, and that money that you set aside for your child, it's your sister's money. Even if everybody knows that that was intended for your child, no, if you list your sister as a beneficiary. So that's not the option. And also, if you don't have any plans in place for that, and there's life insurance or this other assets, who's likely to be put in charge of your child? Now, this isn't always the case. Obviously, every situation is going to be different. But if you were to die, who's likely to be put in charge as far as guardian of the child? Well, that's going to be the other parent. And the question is whether you'd be comfortable with the other parent being in charge of that money. So if you're divorced, and your spouse is living and you die, who's going to raise that child? Well, the courts are likely going to say that it's going to be the spouse. That's obviously not always the case, but it is something that the courts would often give preference to. And if that's the case, then who would be the obvious person to say, well, okay, so if they're raising the child and this money's for the child, who are we going to put in charge of the money? And I think a lot of courts would say, well, if the ex-husband George or the dad George is in charge of the child, well, they should be in charge of the child's money. Now, a lot of folks would say, well, that's absolutely not what I would want. I would not want my ex-spouse to be in charge of the life insurance proceeds. I want to make sure that's used for our child. I want to make sure that that's used appropriately. I would rather have someone else in charge of that. And you can specify that. Just because you can't always have complete control under that situation as far as who would raise the child, you don't want to also potentially give them complete control over the finances, over the life insurance proceeds, over the equity that you have in your house or whatever other dollars that you left for your children. So that can be set out either in a will or a trust, and so you'd really want to set that out. The advantage of the trust over the will is that completely separates it from the court process. So we say, okay, if there's life insurance, if there's equity in the house, if there is a 401k, if there's other assets, we want to make sure that's set aside for the children, and that that's going to be managed for them until they're an appropriate age, that it's accessible through the person I put in charge of it. The way to keep it completely out of the court system would be through a revocable trust, which is basically a contract between you and your family that says, here's how I want my affairs managed. You can also do it through a will and set it up through a will that says, this is who would be in charge of the life insurance proceeds. This is who would be in charge of the finances, and do it through the will. Now, that is going to get tied up to some extent into the court system through that process if you do it through the will. So just be aware of that. Then those are the two options you have for specifying who's going to be in charge of it. But you really don't want to. A lot of people just kind of go automatically to, well, I've got life insurance, I've got a 401k, I'm going to list my mom as the beneficiary even though I have children. I'm going to list my sister as the beneficiary even though I have children. Well, that's very problematic because mom could die, sister could get a divorce, sister could run up a credit card bill. If it's in mom's name and mom dies, that's going to be part of her estate. It's not going to go to your child necessarily. If it's in sister's name and sister gets divorced, half that money is going to go in the divorce. So we don't want to just list the spouse, list your parent, list your sister as the person to be in charge of the money. The other thing, what if your spouse, your other parent is not living? What if you're a widow or widower and you say, okay, well, then is that less of a problem? Not necessarily. So one of the things that we'll often find is we'll say, even with married parents, and they say, well, we want to specify who's going to raise our children. And they say, well, her sister, we want her sister, the wife's sister, to raise the children. But we're not convinced that wife's sister is great with money. And so we'd like husband's sister to be in charge of the money and have wife's sister raise the children. And that's perfectly fine too. You can separate that and often should separate. It doesn't have to be separated. It can be the same person, but you're going to specify through that through a will or a trust. Like I say, the will is ended where the money's going to be tied up in probate for some period of time. It's going to be at least involved in that, but you can specify. The other thing, and we'll get back to this in a little bit, but you don't want to have a situation where your child is 100% in charge of the money once they turn 18. Often 18-year-olds are not ideal at being responsible about money, right? They never really had any context or life experience with regard to money. And so putting an 18-year-old in charge of a $100,000 life insurance policy the day they turn 18 might not be an ideal situation. We're gonna come back to that in a couple minutes here. All right, so the next question after who's in charge of the money is who raises my child? So as I mentioned earlier, the default, what is often going to be is it's going to be the other parent, right? If you're divorced, it's going to be the other parent. If you're a widow or widower, then the court would decide that. And so you need to be able to decide that. Not only, even if there is another parent alive. So yes, the default would be likely. It's not guaranteed, but there's certainly a preference towards the living parent being in charge of raising the children. But I always tell people they should still specify in their will who they would want to raise the children, especially if it's not the other parent, because the other parent may defer, the other parent may die, and then their will might specify who would raise the children. So you'd kind of want your will to say, well, if I have my option, I'd want my parents to raise the children. I'd want my brother or my sister to raise the children. And so even though there is a preference for the other spouse could die. I'm sorry, the other parent could die too, or the other parent could have some situation where they're in the military and they're on duty, or that they just don't step up and they're not willing to be a parent. There's so many different options where you're going to want your will to specify, this is who I would want to raise my children. It's interesting, this is something that a lot of people don't realize, but there's only one document that can legally specify who can raise your children. You can legally specify, this is who I want to raise my children if I'm not here, if I've died, and if I'm able to, if my intentions can be followed through, and that's the will. You can't do that in a trust. You can't do that by writing a note. You can't do that by asking. So a lot of people will say, oh, we got that covered because I asked my sister. Yeah, okay, so you ask your sister, so your sister knows, but the judge doesn't know, and the government doesn't know, and your spouse's parents don't know, or your the kids' other parents don't know, and your parents might not know. And so if you say, I would definitely want my children to be raised by my sister and not my parents, you better specify that, because parents, your parents, the grandparents, may object to that, and they may say, no, we want to raise the children, and if that's not what you want, you need to be able to specify it. And there's only one place to do it. It's not by asking them. It's not by buying them dinner and say, hey, would you do this in the event that I died? It's not by writing a note, handwritten note. It is a will. That is the only legal document where you can specify that. Right. So that's kind of an important aspect. Of course, what if you have special needs children? This is always going to be an issue, not only from the standpoint of we need to specify for any minor children or younger children that there's going to be provisions for how they're going to be taken care of and how the money is going to be managed, but particularly if you have any children with special needs. If it's likely that a special needs child might qualify for medical benefits or disability benefits, you're not going to want to leave them money directly, even when they turn 18 or even when they turn 25, or whatever the scenario is. So you've got to leave it set up in a way that they're going to have the benefit of the money, but they don't have it directly in their name, because if you leave it directly to them, if your special needs child gets an inheritance directly, it's very likely they're going to lose their medical benefits. They're going to lose their disability benefits. So it's very easy to set up a special needs trust. You can do it through a will. You can do it through a trust. There's other ways to set up the provisions. But the idea is you don't want to leave money directly to someone with special needs, even if they're capable. So maybe it's a physical restriction, and they are perfectly capable of handling their checkbook and balancing their checkbook. Unfortunately, in the way that the government works, is that you can't just leave the money directly to them if they're on disability, if they're on medical benefits. Now, there's different types of Social Security disability. There's the type where you've worked for a minimum of 10 years and you've paid into Social Security, and then you get disability. And that we're not so concerned about. That doesn't have restrictions on assets. That doesn't have restrictions on how much assets you can have. But if somebody's on Medicaid, not Medicare, but Medicaid, or if they have SSI, in other words, they did not have sufficient work history where they paid into Social Security before they applied for disability, or they have aid to dependent children. There's a number of other disability programs. Then they may have a restriction on what they can own in assets, and that's where you don't want to leave the assets to them directly. You got to have it set up through a will. You got to have it set up properly through a trust. I will hear sometimes, and attorneys, people will come to me and they say that their previous attorney told them this, and it was that they should just disinherit that child and leave everything to the other child and hope that the other child will take care of the special needs child. That's not the right answer. It's frankly lazy lawyering, because it's not overly difficult to set up your will properly or set up your trust properly to make sure that money is set aside for your special needs child and managed properly, and it's not going to interfere with their benefits. It's not going to interfere with their medical benefits or their disability benefits. It's simply that that it does have to be set up in the proper way. Let's see if I can see this. Okay, how does it's a great question. How does a single parent protect their IRA from nursing home costs? It's actually one of the slides. It's one of the last slides I'm going to have today. So you got to stick with me until a few more minutes here, because I have a slide specifically as it relates to retirement accounts. So we'll come back to that question. All right. I referenced this earlier. What about, just basically you have young children. This would go for single parents or married parents, but if you have young children or young adults. And my point in it is that if you die, we need to have some kind of structure in place to manage whatever finances you leave behind. Hopefully you had some life insurance. Hopefully you had some some investments or some kind of money set aside for the kids. And so if that were the case, you're going to want to make sure that there's some structure as to who would manage it and how long they manage it for. So for younger minor children, you're going to want to specify that, whoever you put in charge of it, your sister, your brother, your parent, whoever it is, but they have the authority to manage it. One way to do it is through a revocable trust, where you set out all that authority ahead of time. Or you can do it through a will, where that authority is set out through the court system. But one way or the other, you're going to want to set it out so that the person you choose has the authority to manage that money on their behalf. So it's not their money. So if let's say you specified your sister as the one that's going to be in charge, your sister, it's not your sister's money. That's very important, because we don't want it to be her money in case she gets divorced, in case she has credit card bills, in case she dies, in case she gets sick, in case she gets in a car accident, in case she goes into a nursing home, in case, any of those types of things. So it's not your sister's money. She is just in charge of it while the child is a minor. But then I say, well, what about young adults? Often we don't want them to be in charge of it when they turn 18, right? There's too many times I've seen people inherit where their parent died when they were younger, and then they get their 18th birthday, and all of a sudden they get access to that $250,000 life insurance policy. Well, that could really do great things for that person, for somebody that's a young adult and maybe should go to school or things like that. But you put $250,000 in cash into the authority in the hands of an 18-year-old, are they likely to use that in the best way possible for them? And I say likely because some of them are, right? There's going to be responsible 18-year-olds. But boy, would that be a temptation, and boy, would that be something that the person, often 18-year-olds, just don't have the life experience for it. Even if they're really responsible, it would be really difficult for them to have the life experience to say, okay, what should I do with this? Who should I get, advice from, all those types of things. So typically we want to specify an older age. We want to specify that it would be managed for them until they turn 21 or 25, sometimes even older. When it comes to, we've had lots of folks in the office lately that had retirement accounts, like IRA accounts, and they say, well, I have a pretty good amount in the IRA. Well, I wouldn't want even a 25-year-old necessarily to have to make all of the decisions about how to get taxed on that IRA and under what terms we're going to get taxed and how long we're going to get taxed and when should I get taxed and all of the details of that. And so they specified a later age. They, in that particular case recently, they said 30. So we're going to say 30, that's going to be managed. That way, some of the decisions that they otherwise wouldn't have had to make, they wouldn't have had any context of making decisions about how you want to get taxed on a retirement account, an IRA. 25-year-olds aren't thinking about IRAs too much typically, right? They don't have any context most of the time of what an IRA is or why they would want it or why it's important or why they might want to save that money or why they wouldn't want to just take that money out when they can. And there's lots of rules and lots of things they can do to make sure that they're going to get more money and Uncle Sam's going to get less. And so in that particular case, sometimes we specify an older age that would allow the older, more seasoned person to make sure that things are set up properly and that they're going to get taxed properly. We're going to minimize taxes on those accounts. So that is something I often will recommend. Okay, this is a really important one. What if you become ill or unconscious? So most of the time we're talking about, well, what happens if I die? I got to protect my kids if I die. Well, we also have to protect your kids if you got in a car accident and live. We have to protect your kids if you don't die, but you get seriously injured. We have to protect your kids and yourself. So it is something that, of course, we're still talking about protecting your kids, but we want to make sure that you have things in place and that you're protected. And so you're going to need some very specific documents. So you're going to want to have, as long as you have somebody that you trust, you're going to want to have a financial power of attorney. Financial power of attorney is going to say who would be able to pay your bills for you if you couldn't do it yourself, who would be able to use the money on behalf of your kids. And your power of attorney, a lot of times people just, get a form document or they download a document from the internet. Well, everybody's circumstances are different. If you've got young kids, your power of attorney should probably specify that the person you've appointed would be able to use that money on behalf of your kids, not just you. Well, most power of attorneys aren't going to have that language in there. Certainly, if you download something from the internet or just get a generic power of attorney, it's not going to have any language in there that's going to say, if I'm in the hospital, if I'm in a coma, if I'm incapacitated in some fashion, if I was in a car accident, that they still have to pay, to make sure my kids are taken care of. That's not in a typical power of attorney. So people often think these legal documents are just forms. They're not in any way. When people come into our office, we ask a million questions because we need to make sure we've thought of everything. And so the legal documents should be customized to the person and what their circumstances are. And we might need to specify something in there that says what happens if you have young kids and you can't pay the bills, you can't get to the bank. Well, we need somebody who would be able to do that for you, not only to pay your bills, but make sure that the kids are taken care of also. Also healthcare decisions, right? So as I was describing that scenario that I suspect some of you thought, well, if I'm in a coma, I just want them to let me go, and then that solves that problem. I don't need a power of attorney. Well, that's one of the issues. First of all, just because you're in a coma doesn't mean that that they could just pull the plug. Sometimes that's not an option because you're just in a temporary coma, or we don't know that it's terminal. In other words, there's lots of times people are in even induced comas to try to help them heal. But the bottom line is we still need somebody to have access to your financial accounts during that time period. But the other part of it is, what if you were in a coma, and what if they didn't think you were ever going to survive, and that you were hooked up to all kinds of equipment, and they didn't think you were ever going to wake up again? Well, how do we deal with that? Are they going to be able to disconnect all that equipment, disconnect the machines? And the answer is, unless you have the proper legal documents, there's a good chance no. And I know that younger folks don't think about this very often, but really anybody over 18 should have one of these documents that says a couple of different things. It says generally what you would want in that situation. but then appoint somebody to convey your wishes for you. In Michigan in particular, it has to be specific that it says, this is the person that knows what I want and will be able to convey my wishes for me. So if it's your, if you're married, it could be your spouse, it could be your sibling, it could be your best friend, it could be your parent, it could be somebody, but you really, in Michigan, do have to appoint somebody to convey your wishes for you. There's that old urban legend that people will, get tattooed on their chest. Do not resuscitate. They don't want to be hooked up to machines, so they tattoo it on their chest or their forehead. Do not resuscitate. Well, it's an urban legend because that's not a legally binding thing. You could literally have that tattooed on you, and they still wouldn't honor it because that's not a legally binding document. There is a legally binding document. Sometimes they call it a patient advocate or a healthcare power of attorney, and this is what you need to specify not only what your general thoughts are on this, but also who would be able to convey those wishes for you. So you need a living, breathing person who can get a second opinion and get details and talk to the doctor who would be able to get that information and do their best to then convey your wishes for you. Okay. So for your what I call the lifetime document, sometimes we're going to have 3 important documents. If you're a single parent, this becomes even more important because especially if your children are younger, it's going to be more important that you have these things in place because anything could happen. You could get in a car accident. Well, you better have these things in place if you got in a car accident, if you had some serious medical condition. I had a client one time, this was many years ago, but I'll never forget it. He fell down the stairs, as simple as falling down the stairs. Younger person, and fell down the stairs, broke his neck. I believe he's still alive, but he'll be in a nursing home. Requires 24-hour care for the rest of his life because simple thing like falling down the stairs. He was a business owner. He was a spouse. He was a parent, and all of a sudden, some random thing happened, and he's going to need care for the rest of his life. Now we don't expect that, right? But things happen, and car accidents happen. And so you're going to need 3 things. You're going to need a financial power of attorney. You're going to need a healthcare document, sometimes called a healthcare proxy or a healthcare patient advocate or a healthcare power of attorney. So they use that term on both, power of attorney for finances, power of attorney for healthcare. So most lawyers use that term for both, but it's 2 separate documents. So when you hear power of attorney, most people think it's one or the other, right? Or that it's one document for both health and finances. You can't do that. In Michigan, you can't do that. It has to be 2 separate documents, one for health, one for finances, but it's 2 separate documents because they're triggered in different ways. They're activated in different ways, and you can't have the same document because it requires different standards, okay? I'm sorry, the third one is so the 3 documents, I gotta go backwards here, sorry, I got ahead of myself. The 3 documents, a financial power of attorney, a healthcare document, sometimes called a healthcare power of attorney, and a HIPAA waiver, HIPAA waiver. This is your privacy law. There's all the privacy laws from a dozen or more years ago about healthcare privacy. So if you've appointed your sister to be able to make decisions for you, but she can't get access to information, then she's not going to be able to make decisions without the proper information. So we're going to want to have a separate HIPAA waiver to allow the person you've appointed and other people. So one of the things about a HIPAA waiver that's nice is that you can also give access to information to other people. So you may not have your brother as the person that's a decision maker, but you'd still want your brother to be able to have access to information or call up the hospital and get a status report or those types of things. All right, and then what I promised earlier was the question was about retirement assets. And you're absolutely right. With retirement assets, those are going to be dealt with separately. There's actually a brand new law. It was passed by Congress and signed by the president in December. It took effect January 1st, 2020. It relates to any of these retirement accounts like IRAs, but it also relates to Roths and 401ks and any kind of retirement account. This is particularly challenging for a single parent because you don't want to list your minor child as a beneficiary. You'd like to be able to protect that. One of the questions is, can you protect it from the nursing home? And the answer is actually that there's a variety of ways to protect from the nursing home. So let me come back to address that question first, but let me address the sort of straight and narrow on this. We don't want to leave your IRA to your child directly if they are a minor. Sometimes we don't want to leave it directly to them for a lot of different circumstances. So under the new law, they call it the Secure Act, which took effect January 1st, 2020. There's basically 3 ways that those IRAs are going to get taxed upon your death. So we're not concerned about it during your lifetime. What I'm concerned about is what happens if you die. And there's 3 different options for how that IRA is going to get taxed or how long you're going to get those Roth benefits. So you remember the Roth, you've already paid the taxes and you don't pay any taxes on any income that you earned or any gain that you gain on that Roth. And so it's a really nice option. So how long can they, after you die, can they keep the Roth benefits? Can they put off paying the taxes on the IRA? And the 3 options are 5 years, 10 years, or longer. And so I have it as red, yellow, and green. Red is 5 years. We don't want to be in the red column at all. Just take that off the table. And so sometimes we need your legal documents to specifically say we're not going to go into that 5-year category. Why? Well, because if we have to pay the taxes in 5 years, we're often going to bump your heir into a higher tax bracket, right? And we have to distribute that out. And if they're a minor, if your children are minors, then that's going to create a real problem because now they're going to have access to that money at age 18 and complete access, and they get to do whatever they want with it. Ideally, though, we would have at least 10 years to pay the taxes on it and possibly longer. And the answer, and this kind of goes into the nursing home option too, but the answer on the IRA is simply that often we're going to want to use a trust. So the idea of the trust is a lot of people think you can't put an IRA in a trust, you can't put a Roth in a trust, and the answer is that's true, except you can do it upon your death. So you can put an IRA or a Roth in a trust upon your death. You can't do it during your lifetime, but you can have it go to the trust upon your death. Why would you want to? Well, the answer is, first of all, because we want to make sure that we're in the yellow column, the 10 years, or the green column, more than 10 years, and that we're not in that red column of the 5 years. Secondly, we might want to have that protected from divorce and bankruptcy and lawsuits and nursing home and all those types of things, right? So the third thing is we might want it to be managed for the kids until they're an older age. I mentioned this earlier that if your kids are 15 and they inherit $250,000 in an IRA, we might not want to put them in charge of it when they turn 18. We might want to say, no, we're going to give them some assistance in how to spend the money and when to take the money and how to pay the taxes and all of that. And so I'm going to list my brother on there as the person who's going to be in charge of that until my kids are age 30. Now, if your kids are particularly, good and financially savvy, then maybe we turn that over to them sooner. But the idea is creating the option within the trust that says it can be managed for them up till age 30. All right, so then the question that was asked goes a little bit beyond the scope of this particular topic, but it's how does a single parent protect the IRA from their own nursing home costs? Well, that can be a bit more challenging, and there are definitely ways to do that. And so it is impossible to be proactive on that. If you go into a nursing home, I've got about 5 different techniques that we can use to preserve 50% to 100% of that IRA, depending on the circumstances. So, like I say, there's about 5 different fact-specific circumstances. In every case, I can protect at least half of that IRA if you go into a nursing home. But what I think most people are asking is, I'm not going into a nursing home tomorrow. I'm worried that I might go into the nursing home in the future. How do I protect it now if I go into the nursing home 10 years from now? And the answer is we can't. What we can do is we can have your proper trust and your proper power of attorney that has provisions in there that says I can protect this later. Because here's why you need that. So we call them extraordinary powers that we add to your legal documents. We add it to your power of attorney, we add it to your trust. Why do you need extraordinary powers in those legal documents? And the answer is because by the time you go into the nursing home, the vast majority of the time, by the time you go into a nursing home, you're not capable of coming into my office and saying, Bob, I was on that webinar back in September 2020. You said I had to wait and get and protect the assets at the time I go into the nursing home, protect the IRA. At the time I go into the nursing home, I'm ready, let's do it. I'm going into the nursing home, let's do it. Problem is, by the time you go into the nursing home, by the time you're that sick, you're usually not capable of making that decision for yourself. You need somebody else to assist you with that, to have the authority to do that. And that's why we need extraordinary. Why isn't it just in everybody's documents? Do you say, okay, well, mine must. I have a power of attorney, I have a trust. It must have extraordinary powers. Probably not. It probably doesn't have extraordinary powers. Why? Because it's extraordinary. It's the authority to preserve assets, including the ability to move them around, and the ability to use certain strategies that are usually not built into a standard power of attorney, usually not built into a standard trust that most attorneys do. Does that mean the attorney did it wrong? No, it doesn't mean the attorney did it wrong. It means that they don't do Medicaid applications. It means that they don't deal with nursing homes. They don't deal with that type of law, and so they don't put those provisions into their legal documents. So the terminology that we often use and is fairly widely used is extraordinary powers. We need to add extraordinary powers to your power of attorney, to your trust, to make sure that we would be able to protect that IRA or a portion of it if you go to the nursing home. But we can't, if you say, well, I'm not going to nursing home anytime soon, but I'm worried that I might in 10 years, the best we can do, we can't protect it now, we can't protect 100% of it, we can't, lock it up or protect it in a lockbox or anything like that. What we can do is add in what we call extraordinary powers so that we would be able to use those techniques when the time comes. So we'd have to do a little bit of legal work now and more legal work at the time that you go into the nursing home. I hope that answers the question. And Savannah, I think that that is my presentation. We'll see if there's any other questions that anybody has. Otherwise, Savannah is going to give you instructions as to how to get other questions answered or to have a general review of your planning to see what you can do to protect yourself and your family.
Thanks, Bob. And as Bob mentioned, a question just popped through. So let's go ahead and see. So this question, now did you say that I cannot put an IRA into a trust while I am alive?
Yes, good question. So an IRA is an individual retirement account, and it is, you can't actually retitle. So most accounts for a trust, we actually retitle the account to the trust. So your savings account, your checking account, the name on the account after we have the trust, after we title it properly and align the assets properly, it would be your name as trustee of your trust. That would be the title on the account. So for my trust, it would be Bob Mannor as trustee of the Bob Mannor Trust. That would be the title on my checking account. With an IRA, you can't do that. You can't have the IRA say Bob Mannor as trustee of the Bob Mannor Trust on my IRA. What I can do, and what I recommend that people do if the trust has the proper language in it, is we list the trust as the beneficiary. So the IRA is in Bob Mannor's name, but upon Bob Mannor's death, my death, the beneficiary lists the Bob Mannor Trust. Now, just so we don't get anybody, jumping to conclusions here, not all trusts have the proper language in there, and I'm going to suggest almost no trusts have the proper language in there unless it was updated, unless your trust was updated within the last month or two, because they just changed the law as it relates to IRAs. And so a trust that was done more than a month ago, and many lawyers don't even have the provisions in there yet, but if we did the trust within the month, it would have the provisions for the new law in there, and you can list the trust as the beneficiary of your IRA. But the trust that most lawyers do, and any trust that was dated prior to 2020, it will not have the proper provisions in there. And not only should you not put your IRA in the trust as during your lifetime, but until and unless you have that update to have your trust comply with the new law, you shouldn't actually even list the trust as a beneficiary on your IRA. So the IRA should only list the trust as a beneficiary if it's been updated for this new Secure Act, which just took effect January 1st, 2020. But yes, that is correct. You cannot actually title the account in the name of the trust until, during your lifetime. But other accounts you can.
Thanks, Bob, and thanks for putting that question in. If you have any other questions, this is the last call for those questions, so go ahead and drop them in the chat. And as Bob mentioned, we do have an easy way for you to get in contact with us, and there's a couple of ways to go about it. I'm actually going to put in the chat box right now a link. This link will let you, when you click it, it's going to open up to a calendar. You'll be able to choose a day and a time that's convenient for you for a member of our team to give you a call. This call will last about maybe 15 minutes. It'll give you a chance to ask us questions about our firm, to discuss your concerns with us, let us know what it is that you're looking for. It'll give our firm a chance to ask important questions of you and make sure that we're the best firm to help you. And also make sure that you're meeting with the best lawyer to help you. We have 3 attorneys on the staff, and they each kind of do their own thing. So we want to make sure that we get you with the best person to meet with you. And if we're not the right attorney for you, we'll help you find one. So I do encourage you to just go ahead and click that link. I just put it in the chat. You're also going to get an email within the next few minutes that in the email, you'll also have that link where you can just click and just access whenever you want. So if you're not near your calendar right now and you're like, I don't know when I'll be available, just check your email. That email will be there waiting for you. So again, I encourage you to just click schedule the day and time that works for you. We'll give you a call about 15 minutes and we'll be able to go from there. You'll either schedule an appointment with an attorney or maybe we'll send you to a different attorney's office. So that should be there for you any minute. And thanks again for joining us today. It's always a pleasure, and we look forward to seeing you again next week.